I might, if we can hold on to those thoughts, and what we might do is go straight to a video question, then we can have a discussion about your remarks, Dr. Appleby, and the question as well. Can we do that now?
Yeah.
The first one is from Hayat Rahimi.
So it's a pre-record.
As of September last year, 39 stateless children were born in Australian detention centres and a further 37 in community detention. Under the Australian Citizenship Act, stateless children born in Australia have a right to citizenship. However, the Minister has yet to grant citizenship to stateless children, leaving many in detention or on temporary visas. How will the Australian Parliament resolve statelessness for these children? Will they be granted citizenship?
More of a question for us than for the panel, but I throw it out there. Professor Rubenstein.
So there's no absolute right, it's a right to apply to the Minister on the basis of that statelessness. So that's why it is sitting in the Minister's office. Now, as a matter of administrative law, if the Minister takes continues to not provide a decision, then there would be a basis under administrative law to challenge the failure to make a decision. So there will be a judicial framework for the applicants to go and seek to resolve that question. It's actually not for Parliament, but it would ultimately be within the court framework under administrative law principles to do with the powers that the Minister has under the Australian Citizenship Act. But the question, I think, raises the broader principles that we've been talking about today in relation to children born in Australian territory in detention and our approach to how Australia should treat those individuals as well as that legal answer.
And it certainly has a link to what Dr. Appleby was saying. Mr. Tran?
The question also links to the overarching idea of baselines that's come up a little bit this morning. Because there's no express reference to citizenship in the Constitution, citizenship is treated as a privilege that is conferred by the executive upon a person. So you have to go and apply for it in those particular instances. If it were to be enshrined in the Constitution, they would set a baseline, whatever that baseline is. And the result would be that it would be for the government to justify why they are removing citizenship from a person. So it does create that shift in the default rule. And so the question, I think, raises some of those larger issues that we've been discussing today.
Any further commentary on the question that's been posed? Yes, Dr.
Simply use the question to remind remind us of the international dimension of deciding to confer citizenship or not. And I know that the Australian Parliament is already alive to this international dimension. It's one of the reasons that currently and under the Citizenship Act, citizenship can be revoked only for dual citizens because it's seen as undesirable to create stateless persons. And the idea that the ministerial discretion is not being exercised when the result is statelessness would seem to feed into this same undesirable consequence, and something that should be feed into that decision.
Just want to go back to your remarks about the, having one class of citizenship rather than differing classes, if we use that terminology. But I suppose that my personal view is that I agree with the sentiments, but then when we talk about the question that, or what Professor Rubenstein pulled me up on before about, actually, if you're Australian by descent, the right of your children to actually get that as well is not automatic. And that's a difference that we put in there, and I can understand why. I mean, if Ireland did that, for instance, how many Australians would be able to claim Irish citizenship? How many people across the world would be able to claim it? So there is limitations put on there for, I suppose, practical purposes, that we don't have the nation flooded with people, basically. That would be why that limitation is there. So I agree with the thrust of what you're saying, but in practicality, it would be difficult to do that, particularly with Australians by descent.
Look, I think that perhaps there is an inevitability about having different classes of citizenship, and what we've been speaking about today about the potential constitutionalisation of citizenship in a sort of baseline sense and having a minimum group of people for whom citizenship cannot be revoked would create classes of citizenship. But I think the conversation that needs to be happening is on what basis are we creating those classes and what consequences attach to those classes, because I think there's an element that people with different protections, different levels of protections, will create an unease in the social cohesion.
Professor Rubenstein, and then I'll move to the committee.
Can I just make another point about this notion of the citizenship by descent to just explain for people the context, so that the notion is that you become a citizen by descent if you're born outside of Australia to Australian parents. So the notion of descent is for people born outside of Australia. So the notion there is that if you're born outside of Australia, then in order to maintain a connection to Australia, if you're wanting to pass it on to your children, then there has to be a connection to territory. So the provision is that you have to have lived, the child of the mainland citizen parent, so the grandchild, has to have spent 2 years in Australia in order to be able to gain citizenship by descent through a parent by descent. Now, interestingly, that's saying, and as a matter of philosophy, is saying connection to territory is significant for citizenship. Yet this current bill is saying connection to territory is not going to be enough for children born in Australia whose parents were not Australian citizens. So I think one of the issues that I write about a lot in my book is the inconsistencies of the philosophical underpinnings of our approach to citizenship. And if we were clearer about those issues to do with residence, to do with familial connection, then there would be a much clearer framework for us to be able to come to Parliament and argue the pros and cons of any legislative change. But at the moment, there is no clarity in those principles.
Okay, committee members, any?
I think Mr. Berg wanted to say
we've got one over. There was someone who indicated they wanted to speak over here. Was it you, Ms. Pillay? And then I'll go to Mr. Berg.
To speak to those points and to your question, Chair, it is certainly possible to allow for flexibility. There's a difference between the question of who shall be entitled to hold citizenship, so who shall be a citizen, and the question of how secure that citizenship is. So it's certainly possible to retain flexibility in terms of working out the parameters of citizenship and still say once people have citizenship, they should stand to hold it in the same sense, and some people shouldn't be more vulnerable to losing it than others.
Mr. Berg?
I'm just going to register a perhaps futile objection that I think that talking about citizenship is really unhelpful in a lot of ways in this discussion, because when we talk about citizenship, we're really talking about a bundle of rights and privileges that sometimes you receive if you're a citizen, sometimes you don't receive if you're a citizen, sometimes you receive anyway regardless of whether you're a citizen or not. So for instance, we commonly associate the right to vote with citizenship, but some citizens don't get that. You get other political rights such as the right to political communication even if you're not a citizen and so forth. I think this is a much more valuable conversation if we start by talking about specifically what we want out of the rights and privileges for the community as a whole, rather than trying to impose what is an overwhelming and complicated and philosophical position about what is citizenship just onto our existing bundle and network of legal rights and privileges.
Okay. Commentary from the committee members?
Well, as I've understood Dr. Appleby and others, the difficulty at the moment is that we've got a Citizenship Act and a Migration Act that between them, once you read them in detail, you might be able to discern, well, definitely, as Dr. Appleby said, that we've got a number of different classes of citizens, which has grown up by default since we created Australian citizenship in 1948. And because there is no statement anywhere in Australian law about what citizenship as a whole means, we've got this existing position of the uneven patchwork of rights, and changes to that uneven patchwork of rights are now being determined without reference to any principle. So in the bill that is before the Parliament at the moment, which makes a change to the Migration Act in respect of the Minister's power to cancel citizenship of someone who has acquired the citizenship by naturalisation in much different circumstances to the present, and the other change, which is this change to the 10-year rule, can anyone suggest what is an appropriate framework against which either of those changes might be able to be judged?
Will there be implied constitutional principles that you'd be arguing about the limitations of the Parliament to withdraw membership from the community, a constitutional concept implied into nationhood of some sort? But we don't have any, I mean, these are matters that will need to be developed.
It's not something on which there's current authority in the High Court?
No.
There isn't something for which there's current authority in the High Court, but we could reason by analogy from the way in which the High Court has approached the question of an implied right to vote. So at Federation, we didn't have a universal franchise, and that was constitutionally acceptable, but in the case of Roach and Electoral Commissioner, the High Court said now we do have a constitutionally protected universal franchise, that there are only very limited circumstances in which Parliament can decouple the right to vote from statutory citizenship. So the way in which the constitutional right to vote is defined is by reference to the way in which Parliament defined the class of electors, and it's possible we could utilise a similar approach to set limits to how Parliament's capacity to define citizenship. There's no authority, but it's arguable.
I think the short answer is we're groping around in the dark, attempting to get some sense about a concept that has no fixed or clear meaning in the Constitution, yet obviously is of vital importance in a range of contemporary debates, and hence we keep coming back to that point that unless it's going to be riven by this uncertainty and incoherence, then ultimately, Parliament will need to take some steps.
To many observers, the High Court's actions in the electoral cases demonstrate why it should not have power under a Bill of Rights to determine, for example, that I think it was if you're in jail for 3 years, that's too short to lose your right to vote, but 6 years is all right. Now, where do we find that? And to say that people in breach of the Electoral Act should still have a right to vote after Parliament has decided that the rolls be closed at the time the election is called is wrong, but leaving the rolls open for 6 or 7 days is all right. These are very arbitrary decisions which the High Court justifies on some constitutional principles which some of us doubt exist. And this creates a feeling among many observers that it would be dangerous to give the High Court specific powers to reel in fields where it's already seizing power.
I think the 100,000 Australians who got their votes back at the 2007 election as a result of the High Court's decision would be very satisfied, Professor
Yes, I
Flint.
was delighted with that.
Professor Rowley?
I think, although we don't know what the High Court's going to do, we do know the kind of principles they're going to look at, and that is what underpins citizenship anywhere. There are three concepts. There's birth, there's descent, and there's residence or connection to territory. And any of our, as Professor Rubinstein said, in the Citizenship Act at the moment, it's a combination of those things that gives us citizenship, both which is automatic and citizenship which is conferred, which is based on will you come and live in the territory for a period of time. So I think as a community we have to look at what is important to us as the fundamental connection to being Australian, and it's going to be a combination of those. I think in the modern world where people move around and allegiances are more than singular, people have dual or multiple allegiances to places, that complicates the whole question of citizenship. I don't think there's any question about that. Can you have multiple allegiances, and can you vote in 3 or 4 different electoral processes and still be committed to that country? That's clearly a question. But I think the big one that is growing, and I think necessarily will have to grow as the basis of connection is when someone has lived in a place and has contributed to that place through their work and through raising a family or whatever they do, that's going to be the most solid connection that we can have. And which is why I think that the High Court, my speculation is that when they look at a child who's been here for 10 years, that they'll find it very hard to find that they are an alien to this country.
And on that front, we've had a suggestion from Rex Drabick on Twitter, who says that he thinks citizenship eligibility time should be at least 5 years with a probationary period. And I suppose it just goes to the whole issue of how do you sort that out? What are the community sentiments on that? Dr. Appleby, you wanted to, I saw your hand up before wanting to make...
sorry, I was, and I actually think that Professor Riley has already raised these points, and I was going to say that when we come to assess the current framework for citizenship and who is a citizen but also who is an alien and who can be subject to immigration administration and detention, we can assess them by reference to constitutional principles, but we can also assess them by reference to more fundamental principles, and these are the principles that we've spoken about: birth, descent, connection to territory, connection to community, contribution to community. And those types of principles, even if there is no constitutional basis, we don't know, the High Court hasn't told us, they can still form the basis of our discussion as a community in this committee, in the Parliament, as to whether these amendments should go through, whether they're constitutional principles or not.
Do you have questions from members of the audience?
Just